Torture shadows India's justice system. The article is taken from the newspaper The Hindu, which is talking about India's failure to criminalize torture, and it weakens the Indian judicial system and global reputation, because in the year 1984 almost every developed nations in the world ratified the United Nations Convention Against Torture, but India signed this in the year 1997 but did not ratify the convention so far. And recently in the United Kingdom, as well as the Supreme Courts of United Kingdom and the United States, has raised concerns about the custodial torture in India. And we know that recently the Trump administration accepted to transfer Tahavur Rana, one of the conspirators in the Mumbai terror attack of 2008. And in that case also the United States Supreme Court raised concerns about the person in India. So coming to the legal framework for torture, see, before that we have to understand what is meant by torture. Torture, according to the United Nations Convention Against the Torture, torture means an act of intentionally inflicting pain or suffering on another person, both psychologically or physically. And in the case of India, we don't have a specific law to deal with the torture, but we have constitutional provisions, that is Article 21 of the Indian Constitution, that is right to life and personal liberty, which ensures freedom from torture. And then we have the Article 20 Clause 3, which Article 20 provides protection against arbitrary arrest, and that protects the people from self-incrimination. That means the police or authorities cannot force a person to confess that he committed the crime, and they cannot ask the person to submit evidence against himself. And also we have certain Supreme Court cases, so you can address these cases while you are writing an answer. First is the DK Basu case 1997, and here the Supreme Court provided guidelines against the custodial torture. And then we have the Puttaswamy versus Union of India case 2017, and here the Supreme Court reinforced the guidelines and also reinforced the principles of dignity and the right to privacy. And then next we have the Ashwini Kumar case 2019, which recognized the need for an anti-torture law in India. And coming to certain recommendations, the Rajya Sabha Committee 2010 and the Law Commission of 2017 urged a standalone anti-torture law in India. So coming to the international commitments, we have the United Nations Convention Against the Torture, and this was adopted in the year by the United Nations General Assembly in the year 1984, and India signed this in the year 1997 but did not ratify so far. So what is the meaning of signing and ratification? Signing means we are ready to consider that we are accepting the existence of such a convention or a treaty, but that will be legally binding only if we ratify the convention or the treaty. And this approach of India, placing India among the nations with poor human rights records like the Burkina Faso, Sudan and all. And coming to the constitution mandates, Article 51 Clause C and 253 empowers India to enact laws aligning with the treaties, but no actions have been taken so far. And coming to the challenges in enacting an anti-torture law in India, first is a political and bureaucratic apathy. That means we can see the Rajya Sabha Committee made the recommendation for a standalone law against the torture, while you can also see the Law Commission also made the recommendation, but still it is ignored by the government, by the different governments. And the next is police brutality and lack of accountability. That is, torture persists due to weak enforcement of the law. And the next is a weak oversight mechanism. There is no independent authority to monitor the custodial violence. There we have the State Human Rights Commission, National Human Rights Commission, but still you can see that they perform multiple functions, but there is no independent authority to monitor the custodial violence alone. And the next is fear of international scrutiny. That is, ratifying the United Nations Convention Against the Torture would invite global human rights monitoring in India. And coming to the implications of this inaction, that means India has not ratified the United Nations Convention Against the Torture. So what are the problems may arise from this? First one is the hurdles in the extradition. That means, like I mentioned, in the cases Tahavur Rana, the United States Supreme Court has raised concerns about the safety of the people in the Indian custody. And the next is erosion of the democratic values. That means the custodial torture often violates the human rights, even violates the Article 21. And you can see that in 2020-21, during the time of COVID, a father and a son was severely tortured in the custody, and both of them died. So therefore, if there is no standalone law to take action against the custodial torture, then it contradicts India's commitment to justice and human rights. And the next is global reputation damage. That is, non-ratification places India among the authoritarian regimes like I mentioned, Burkina Faso, Sudan, Haiti, and all. And we know that we have the badge of the world's largest democracy, and we have to protect it. For that, we need a standalone law to act against the custodial torture. So what can be done to enhance the safety of the people in the custody? First one is the enacting a strong anti-torture law, that criminalizing the torture in the custody explicitly. And the next is ratifying the United Nations Convention against the torture, which will strengthen the India's credibility in the global scenario. And the next is judicial and police reforms, that is strict oversight and monitoring to ensure that the people are treated properly in the custody. And the next is independent investigation mechanism, specialized body to investigate and monitor the torture cases in the custody. So in this topic, we discussed the importance of a standalone law against the torture, against the custodial torture, and what are the problems that can be arise if we are not taking an action to ensure the safety of the people in the custody. So based on our discussion, try to answer this mains practice question. The question is, discuss the need for a comprehensive anti-torture law in India. How does the absence of such a law impact India's legal system and global reputation? So we know that the need is of a comprehensive anti-torture law is essential, because it is needed to protect the fundamental rights of the people, ensure the global reputation of India, and also India can make better advocation for the human rights in the global scenario. And these are the need to achieve all this. We need a comprehensive law against the torture. And the next is, how does the absence of such a law impact India's legal system and global reputation? That means, it will damage India's global reputation as a human right advocate, and at the same time, it is placing India as one of the dictatorial nations like Sudan and Haiti and all. And the next, you can see that absence of such law can violate the fundamental rights. And also, finally, in the way forward, you can talk about the need for an independent authority or a body to regularly monitor the custodial safety of the people. And you can also talk about the need for ratification of the United Nations Convention against the torture. So based on our hints, try to answer the question and post it in the comment section. We will review and we will reply for your answer.